Morning, everybody, and welcome to the last day of the hearings for the small freshwater part of the RPS. I have to start with the usual summary about safety. If we have any emergencies, doors at the far end of the room, and we gather outside the Spates Ale House, sort of throughout the same doors. Otherwise, I just ask everybody to keep their cell phones off, and we're underway. Friends, so where are we starting?
Well, the first thing is that there was a question from Mr. Langman yesterday to do with the infrastructure chapter. Just find while I'm talking, to which he has delegated the task of answering to me. So I will do that. So the question concerned EIT infrastructure P13 1F, which was to do with historic heritage, and the words significant or outstanding having been deleted. And the query was sort of why has that happened, because the footnote is simply to clause 16. The answer is in fact found in the historic heritage reply report at paragraph 56, subclause 6.
Is it the reply?
Yes, the reply report.
Sorry, what paragraph number?
Paragraph 56 of the reply report for historic heritage. And this is probably as simple as having the reference.
I guess my question around that is that it's not a minor change. Use that provision. It was an error.
That's a good point.
It was correcting an error in historic heritage policy 5, which, as notified, required using EIT INFP 12 to manage the effects of infrastructure and all types of historic heritage.
Yep. So this
But
is
it
the
wasn't
consequential.
That's right. It wasn't reflected in the EIT policy. Yep. So it was just correcting that error.
Yeah, if you the references are the paragraph in the historic heritage reply report I've just given you. Historic heritage policy 5, where subclause 6 has all historic heritage or infrastructure being dealt with under EIT INF P13. The consequence of that in terms of infrastructure P13 is that firstly infrastructure avoids locating in those areas if practicable, but if not, then it defaults to, and this is 2B, avoid adverse effects on the values of, rather than having to comply with the full historic heritage policy Historic Heritage Policy 5. And so that's the intended regime which was provided for in the notified version of the plan in the Historic Heritage chapter. And as Ms. Boyd just said, the change to infrastructure P13 is correction of an error. That reason is explained in the Historic Heritage reply report.
Thank you.
All right, and so Ms. Boyd is sitting next to me to add to our reply report.
Yes, yesterday it was identified that I had not filled in one of the paragraphs of my report. Paragraph 62 of reply report 6 had a missing section 32 AA analysis, which I have prepared. I've sent an electronic copy to the hearings administrator, but I propose to just read it out so that it's on the record. I consider my recommended amendments reduce the stringency of the entry criteria for IMP 12, meaning it may be available to more activities when compared to the notified provision. The consequence is that there is an increased risk of costs to the environment as a result of contravening limits. However, I consider this better reflects that, as set out in the chapeau, the policy is for use only in situations where an activity provides enduring regional or nationally significant climate change mitigation. Therefore, there is also a benefit to the environment as well as people's well-being in the form of climate change mitigation. In my view, this improves the effectiveness of the policy at achieving IM Objective 4 and is more efficient than the notified provision due to the potential for greater benefits for the environment.
Thank you.
So you'll recall that yesterday we ended with legal submission such as it was on the urban form and development chapter. So Ms. White, I believe, is about to connect to answer any questions you might have on her reply report.
Good morning, Ms. White. Can you hear us?
Yes, good morning.
Now, look, I'm not sure whether yesterday you heard that description I gave that we are not really challenging report writers by way of questioning on this process. We're listening and only really asking questions to clarify these reports at this stage because we've been so well informed as the hearings have progressed. So don't feel upset if you're not asking any questions. That's just a credit to you for clarity. But equally, there may be some. And again, I'll start with Commissioner Cubitt. Yeah.
Thank you. Morning, Ms. White.
Morning.
Just a couple of points of clarification. Top of page 14, your amendment to P76. And it's around the restricting the establishment of non-rural activities. Just a question around that in terms of the way that's written. I'm assuming that that's not prohibiting non-rural activities within the rural sort of area. And what I'm thinking about there is sort of non-rural activities that support rural communities. So it's not a prohibition, is it, the way that's drafted?
No, and the intent of the drafting is that that's read with the following wording, which is restricting establishment of non-rural activities which could adversely affect, including by way of reverse sensitivity or fragmentation, the productive capacity. So it has to be read in that full context. So it's not full stop at non-rural activities. It's those types of activities that could have that type of effect.
Okay. And the only other thing I had, because your report was very clear and we had the benefit of your earlier redraft, was the question around it at your 7.2, your section 7.2, is the issue with the transition industrial zone to commercial or whatever it may be. And you made a comment here that there'd be no direction in the RPS level as to what tests such a transition would meet. Well, I guess I'm just wondering why does an RPS even need a test around that? Given, well, I wouldn't even say it as a regional issue, it's possibly an issue for Dunedin. So what is the concern around that from a regional point of view?
First of all, I think that's a valid question. If it's something that the panel considers is not addressing a regionally significant issue, then it's definitely within the scope of submissions to remove that direction entirely. I think that the reason that I see it as being important is because it actually provides a test that is not otherwise there, which is around that significant operational need for a particular industrial activity or grouping of industrial activities, is essentially where you get to in what's now redrafted in clause 4A. And I think that that's where it's saying where you have the types of activities that are actually really quite important, there's that additional test put in place. So that's why I see that sitting at the RPS level, is because it's only adding that test where it's in relation to that significant industrial activity or grouping of industrial activities. But just to reiterate that if the panel considers that that's not something that needs to be considered at the RPS level, then there is scope essentially to remove that direction.
Yeah, okay, thanks for that. Yeah, just from local knowledge, I would expect that to only be an issue in some areas in Dunedin, but well, the only other thing was you're sitting in Christchurch right now, I assume?
Yes.
Yeah, UFD M2, 3F, reduce the adverse effects of Otago's cooler winter. I hope that's in the Canterbury RPS, because we have a far colder winter than us.
I can't take the credit for that one.
It's just being silly as usual. Thanks, Liz. Your report was really useful. Thank you.
Thank you, Ms. White. No further questions from other commissioners. Thank you.
Thank you.
Yeah, so it pleases the panel, the order from here, noting that Mr. McLennan has 3 chapters for today. I thought it's probably best to do those one after the other together, and that we might start off with the eco chapter and then move on to Mr. McLennan's 3 chapters. Okay. So, ecology. So I've just found it. So in my submissions, that begins at page 62. So while we're finding that, I should inform the panel that in attendance to answer any questions, Mr. Lloyd and Ms. Hardiman, and that you will have noticed attached to the reply report there is a further report from a coastal ecologist, Ms. Miller. So Ms. Miller is available for any questions the panel might have at 10 a.m. So turning to the submissions on the eco chapter, there are 7 points to be addressed. First is meaning of protect as against maintain. That's the section 6C versus section 31 GA point. Second point to deal with is the management of significant natural areas together with tauka. Third is the appropriate scale for protection, i.e. nationally, regionally, district level, some other level. Fourth point is the impact of section 104.1AB on limiting the availability of offsetting and compensation. Point 5 is prescriptive limits and NPSFM alignment. Point 6 is the legality of Eco P5. And finally, there's a quick response to the memorandum that was filed on behalf of Sanford the week before last. So the first point to address is the distinction, if any, between use of the words protect and maintain. The Regional Council's submission at the hearing was that a Regional Council has a mandatory statutory obligation to maintain Indigenous biodiversity. Section 31 GA provides every Regional Council shall have the following functions for the purpose of giving effect to this Act in its region, and GA is the establishment, implementation, and review of objectives, policies, and methods for maintaining Indigenous biological diversity. And then the submission went on to say to maintain means to protect, which in turn means to keep safe from harm. The question the panel asked the Regional Council to reconsider was to reconsider its position with respect to the meaning of maintain. At the hearing, the panel viewed this as a submission that all biodiversity, no matter how insignificant, was elevated to a matter of national importance because the direction in section 6 is to protect. Now, before running through the case law on the use of those terms, which essentially tells us that protection is one way that something can be maintained. The important point to note is that the submission of the Regional Council is not that section 30 considerations generally are elevated to the same status as section 6C. And in practical terms, that is the distinction between significant Indigenous biodiversity and the remainder of Indigenous biodiversity. In the regional policy statement, those two things are treated very differently. And if we're talking about that in terms of protection, the protection for significant Indigenous biodiversity to give effect to section 6C in this regional policy statement is much higher. And for the remainder of Indigenous biodiversity, there is a lower level of protection, but nonetheless provisions designed to maintain that. I was looking at this last night, and I must confess I possibly wasn't thinking as clearly as I could have been, but refreshing my memory as to how one is to navigate around the different provisions that impact on biodiversity. Because you have the provisions in the EIT infrastructure chapter and the provisions in the eco chapter. And if you are looking at a particular thing, for example, just plain old infrastructure, you go to the infrastructure chapter and you see that there are some obligations, and then if it's just plain old infrastructure, mostly you're going to remain within the infrastructure chapter. But if you are, actually it might be helpful to go to these provisions. So if you're infrastructure and you're outside the coastal environment, you would go to P13 and you see that that applies to you. And in 1A, you see that as a first priority, you're to avoid locating in the following areas, and that is significant natural areas, which is significant indigenous biodiversity. And then you go to 2, and if you look at 2B, because 2A only applies to nationally and regionally significant, you see that you have to avoid adverse effects on the values that contribute to the area's outstanding natural significance. So that's an example of where it's quite simple and straightforward. However, if you are significant or regionally significant infrastructure, you would be at 2A, and then you see that you go to Eco P4. And it's P41, and you'll see that you need to have a functional or operational need to locate in a significant natural area. But you'll see also that for any kind of biodiversity, as well as significant natural areas, you're taking yourself off to Eco P6, which is the effects management hierarchy. And so just for me, just looking at it, it's not immediately obvious how the two things are treated differently. So to illustrate that, what I've done essentially is to make myself a little table which looks something like this. And I would share, but for the fact that it's illegible, which tells me all of the provisions that apply to significant natural areas and all of the provisions that apply to other biodiversity. And so I thought the best way to illustrate this point is simply to take you through the position for a significant natural area and then contrast that with the remainder of the indigenous biodiversity areas. So if we're talking about a significant natural area, the first thing that is going to apply is Eco P2. And that is the requirement to identify the areas and values. So for a significant natural area, the first thing that's going to happen is it's going to be on a map somewhere and its values are going to be identified. Then, in terms of Eco P3 1A, for everything except infrastructure, mining, and certain Maori activities, there is a requirement to avoid adverse effects that result in any reduction of the area or any loss of values. And that's a pure avoid, as in don't do it, and if your activity would do it, then you can't do it. The next thing on the list
Sorry, just before you move on to the next thing, what were those exceptions that you said for everything except?
So the exceptions are found in Eco P4, and in summary, they are all forms of infrastructure, whether significant or not. Mining and aggregate extraction with a functional need of certain levels of national or regional benefit. And certain Māori uses, which are Eco P4, 2, 2A, and 3. So the next thing that's on the list for significant natural areas is if we're talking about infrastructure, whether it's regionally or nationally significant or not, INF P13.1 requires avoidance of those areas if that is practicable. And the practicability relates to the functional and operational needs. So essentially, infrastructure has to avoid if it can.
And you pick up practicable from 2.
Yes, that's right.
Yeah, right.
And then the next step in the process for significant natural areas is you get to the effects management hierarchy in Eco P6. And that's the avoid, remedy, mitigate, offset, compensate hierarchy. And then there is one final part of the process for the overall hierarchy for significant natural areas. And that is that for infrastructure which is not regionally or nationally significant, the provision which applies is INF P13 2B, where if the avoid locating is not practicable, your default position is to avoid adverse effects on the values that contribute to the area being significant. So that's the list of steps or potential steps that apply when you've got a significant natural area. if it would help, I could have my hieroglyphics typed and take them
I
out to
think it
lunch.
would be very helpful.
I'll do that. So if we turn to the non-significant Indigenous biodiversity, so this essentially is to give effect to section 31 GA. We don't have a requirement to map under Eco P2. We don't have a requirement to avoid a reduction in area or values under Eco P3. And we don't have a requirement to avoid locating in, if practicable, for infrastructure under INF P13. What we do have is moving straight to the effects management hierarchy in Eco P6. Which is the avoid, mitigate, remedy, mitigate, offset, compensate hierarchy. The key point about that is that because we're not talking about significant Indigenous biodiversity, quite apart from how easy or hard to avoid, remedy, or mitigate might be, offsetting and compensation as ways of avoiding, not ways of avoiding, as ways of dealing with effects which you're not able to avoid, remedy, or mitigate, is a much easier proposition than for significant Indigenous biodiversity. Because by definition, what you're dealing with is not significant. And so you don't run into the sort of hurdles that that have been discussed to do with limits on the availability of offsetting and compensation. And I highlight that because just looking at P6, you think, well, the same hierarchy applies. But when you look at how easy or hard offsetting and compensation would be, almost by definition for the non-significant stuff, you know you're going to be able to do it because you don't have any significant values that would limit you. So that's the end of my table, which I'll somebody type and hand up after lunch. Returning to the written submission. Pages 63 and 64 up to paragraph 403. Outside of case law, where essentially the words protect and maintain are either being used interchangeably or describing protection as one of the ways that you might choose to maintain under section 30. And I don't propose to read all that out. the key point for the regional council here is that our submission, or my submission, is that Section 6 matters do have to be treated differently to non-Section 6 matters which fall under Section 30, and that the regional policy statement does just that in the way that I've just described. And I'm thinking that I'm going to move on to the next point, because the written submissions are really just recording what I've just said in different words. So I've leapt ahead to page 67, which is significant natural areas and Taoka being dealt with together. So the proposed regional policy statement manages Taoka together with significant natural areas by requiring their identification in accordance with Eco P2 and their protection in accordance with Eco P3. During the Eco hearing, the panel noted that the direction in Section 6E is to recognise and provide for the relationship of Māori with Taoka, whereas direction in Section 6C is to protect areas of significant Indigenous biodiversity. The question is whether it's justifiable to treat the two things the same, given the different wording in Section 6. In short, my submission is that the answer is yes, and the reason is that preserving the Taoka is an important part of recognising and providing for the Māori relationship with it. And in paragraph 4 and 9, I see there's a stray S at the end of the word Māori, which shouldn't be there. And essentially what I'm saying is that when you're talking about Taoka, it's very difficult to see how you can recognise and provide for the relationship with it without also protecting it in some way. And also, I'd add to what's written down here that by definition, it is something that is special. That's the nature of it. I note also, and this is paragraph 41, that this is consistent with Section 8 of the Act, which provides an achieving purpose of this Act, all persons exercising functions and powers under it, skipping ahead, shall take into account the principles of the Treaty of Waitangi. Principles of Te Tiriti require active protection of Māori interests, which include Taoka species. There was also a concern expressed at the hearing as to how widely the provision, which is the avoid provision in Eco P3, could apply, because at least in the Otago context, some of the species that are Taoka are quite abundant, and that's resulted in the reply report writer conferring with Kaitahu and proposing an amendment, which I should just flag. So if we look at Eco P2.2, words have been added, including those identified by Mana Whenua as requiring protection. And those words appear also in Eco P4 at the end of the introductory words. And the concept is that the tauka to be protected is the subset of all tauka which has been identified by mana whenua as actually needing protection. As a valid point was made of hearing that in Otago that ends up being quite broad. So the next point in submissions is the appropriate scale for protection. And this is at the bottom of page 67. Panel has asked whether the protection of areas of significant Indigenous vegetation and habitats of Indigenous fauna is to occur at the ecological districts scale, district scale, a regional scale, or a national scale, and has inquired whether there is any case law which provides guidance on the appropriate scale. Excuse me. The short answer is that there is case law, but it doesn't necessarily provide hard and fast guidance. So the first case cited is at paragraph 427, which is the Manor Station case, which related to 6B factors, i.e. Landscape and natural features. The finding there was that the assessment is essentially a factual assessment based upon the inherent quality of the landscape itself. But there was a statement that in that context, for a regional policy statement, the regional scale is an appropriate scale for determining outstanding natural features in landscapes. There's a case, Royal Forest and Bird Protection Society and Auckland City Council, which held that the same principle must apply to section 6C matters, i.e. biodiversity. Paragraph 428 is an extract from Forest and Bird and New Plymouth District Council. Areas of significant Indigenous vegetation and significant habitats of Indigenous fauna, which section 6C seeks to protect as a matter of national importance, include areas and habitats of regional and district significance. In this case, the SNA is subject to these proceedings. The context there was a district council, district level. So regional and district significance were considered to be okay in that case. Then there's Minister of Conservation, Western Bay of Plenty District Council, where the Environment Court said, importantly, in determining whether an area of Indigenous biodiversity, which is me paraphrasing, is significant for the purpose of paragraph C, the area or habitat is not required of itself or in combination with other areas or habitats to be nationally important. Neither does its importance have to be regional in character or otherwise exceed the bounds of the planning district. Rather, it's a question of identifying and assessing, with the aid of qualified advice and assistance, those areas or habitats that are significant within the district as to require protection. So it appears from the case law that an area may be significant under section 6C because of its national, regional or district significance. And I would add to what's written down in the submissions that in this policy statement, we're making a direction that's to be applied by territorial authorities, i.e. at the district level. And it is clear from the case law that for district councils seeking to identify significant natural areas, they can include things which are significant at that level. There's an interesting case, just mentioned for completeness, of paragraph 431, West Coast Regional Council and Friends of Share a Swamp, And the reason that's interesting is that there was an item of national significance, but in the area concerned, it was quite abundant. So for the West Coast, at a regional level anyway, the assertion was that, well, we wouldn't consider this significant, but at a national level, scarcity meant that it was. And essentially the finding was that, well, that's just tough luck. If you've got something nationally significant in your region, it's still nationally significant, even if you've got quite a lot of it at a regional scale. That's relevant because I think some of the evidence, actually, I'm not sure if it's been evidence in this here or not, but in the Macraes district, there are critically endangered ephemeral wetlands, which are relatively abundant, but nonetheless significant. So in light of all of that, I'd make the observation that thinking solely in terms of whether something is nationally, regionally, or at a district level significant isn't the totality of the exercise. There's a fairly comprehensive list of factors that are relevant to the consideration in App 2. And the key part of the exercise is ensuring that those factors are themselves the right ones to use. And so the submission that I'm making here is not about whether the factors are right or not, it's for the experts, but just to observe that not all of the factors lend themselves to thinking in terms of national, regional, or district level. And I think the appropriate focus in terms of how this regional policy statement directs identifying what's significant or not significant is those factors in Act 2 based upon the expert evidence. So section 104.1 AB. Just as context. Tell you exactly what that section says. Bear with me for just a moment. So what 104, of course, is to do with consideration of resource consents. And so the relevant words read, the introductory words for subsection 1, when considering an application for a resource consent and any submissions received, the consent authority must, subject to part 2 and section 77M, have regard to, and then AB is any measure proposed or agreed to by the applicant for the purpose of ensuring positive effects on the environment to offset or compensate for any adverse effects on the environment that will or may result from allowing the activity. And so that's an obligation on those considering consent obligations, applications to take account of any offsetting or compensation measures. And the submission that's been made by Mr. Christensen for Oceana Gold is that because of section 1041AB, it's now unlawful to have something in a policy statement or a plan which says that offsetting is not available in some circumstances, or put differently, is only available in specified circumstances. To support that submission, Mr. Christensen cited a case, Forest and Bird and DCC, where Judge Stephen referred to the fact that section 1041AB is now law and did not apply when the Environment Court settled 5.46 and 5.46A of the 2019 policy statement, which are the provisions relevant to offsetting and compensation. The OGL submission is that those policies would now be different because the law is different. My submission is that that's not correct. Another recent case of Judge Stevens, Forest and Bird and West Coast Regional Council and Buller District Council, where she held, due to the wording of the policies in Chapter 7 and the very directive approach of the NPSFM in relation to biodiversity values, we are prevented from accounting for the offsetting and or compensatory measures proposed by the applicant in terms of our consideration of proposal under those instruments, notwithstanding their relevance as positive effects in the context of section 104A. However, it's for the court to decide what weight should be given to the matters of relevance identified in section 104. We find that these positive effects relevant in the section 1041A context do not overcome our effects-based findings on the ecological effects that have informed our 1041B evaluation. The reason for citing that is that it is the first paragraph that's cited the RPS provisions relating to offsetting and or compensation. That decision was on an application for resource consents for a coal mine at Te Kuha on the west coast and directly engaged section 104. While section 104.1AB did not apply in that case because of the lodgement date of the application, Judge Stephen held nothing much turns on that as the positive effects are able to be considered under section 104.1A. So I'd submit that Judge Stephen's comment in the first cited case, Forest and Bird and DCC, can't be taken to mean that limits on offsetting in specific circumstances are now inappropriate or unlawful. The judge was not asked to decide that question and did not do so. At most, the judge's observation indicates the result may have been different, but for the reasons below, that does not follow. Next point about that, the advice given by the Ministry for the Environment in a briefing paper to the Select Committee on the Resource Legislation Amendment Bill, which introduced section 104.1AB, gives insight into Parliament's intention when enacting the provision. I'm not going to read out that whole extract, which is at page 72, except to highlight to you the final underlined passage, which is, it will also be possible for the objectives and policies of RMA instruments to specify whether offsetting is either acceptable or unacceptable in certain situations. In other words, the advice to the Select Committee was that offsetting and compensation proposals under section 104.1AB would be evaluated through the lens of relevant policies, which may include bottom lines, but more relevantly may include restrictions on when offsetting or compensation is available. Paragraph 442 is citing what Ms. Burkhardt had to say on this point. When asked about it at hearing, which I don't have to read out because it's saying what I'm about to say. So I'm now at paragraph 443 on page 72. An applicant's offer of compensation or offset is a matter to which consent authority must have regard under 1041AB. So if something's put up, a consent authority has to look at it. Equally, consent authority must have regard to the relevant policies and objectives of a regional policy statement under section 1041B. One of the functions of a regional policy statement is to have provisions which inform, guide and direct decision making on the use and development of and protection of resources. Subordinate instruments, i.e. the plans, express that in greater detail. The situation with 1041AB is no different to, the legal position on what plans and policy statements can say is no different to section 1041A, which allows regard to any actual and potential effects. Policy statements and plans regulate how effects under 1041A are to be treated and how consent decisions are ultimately to be made. That's exactly what was happening in the Te Kuha case that was cited earlier. In fact, every consent decision measures effects against objectives and policies of planning instruments. So the simple point I'd make is that the submission that 1041AB, because it allows the consideration of offsetting and compensation, prevents plans and policy statements from dealing with the circumstances and manner in which offsetting and compensation can happen, simply must be wrong. There is a whole list of things that consent authorities are to consider. Under 1041, plans and policy statements provide rules which relate to lots of things, but include the restriction of what effects are permissible and what effects are not permissible, and when something is discretionary and when something is to be controlled, and what performance standards must be met, and so on. And if the proposition that because a consent authority can consider something means that plan or policy statement can't deal with it is correct, then because of section 1041A, which allows the consideration of any actual or potential effect, that would, if it's correct, essentially make plans and policy statements redundant. The more technical reason why it can't be correct is that when you look at the introductory words of 1041, the consent authority is having regard to those things subject to part 2, i.e. section 5, 6, and so on. The higher order policy instruments are effectively telling the consent authority what part 2 means in that context. And part of that can be saying that in certain circumstances, offsetting compensation should be available, or how offsetting compensation should happen in certain circumstances to give effect to part 2. So if you then take yourself to 1041AB, which says you can consider any offsetting and compensation, you have to read that as subject to part 2. And in this RPS, we're saying that to give effect to part 2, you need to have limits on offsetting and compensation. And that's what paragraphs 448 and 449 of the submission are dealing with. So turning to prescriptive limits and MPSFM alignment. Related to OGL submission on the legality of prescriptive limits, which was the previous point, OGL has sought the effects management hierarchy in the MPSFM to be applied to terrestrial ecology in the regional policy statement. The reason for that is that the offsetting provisions in the MPSFM refer to principles rather than what was described as presumptive limits in the regional policy statement. So on the question of whether the principles in the NPSFM offsetting criteria and compensation criteria are appropriate in the terrestrial ecology context, as opposed to the criteria which are set out in appendices 3 and 4 of the regional policy statement. I defer to the expert evidence, and Mr. Lloyd said to answer any questions you might have on that. From a legal perspective, there's just a submission that the proposition that the principles in the MPSFM offsetting and compensation appendices are somehow legally different to the criteria in the appendices to the RPS is partially wrong, partially correct. I say partially because some of the principles in the MPSFM appendices must be complied with, meaning that they're, despite having the label principles, they're not in fact any different in effect to what's being done in the regional policy statement. The principle that you must comply with is just the same as a criteria that you must comply with, and that the relevant reference to that is 3223A Roman 2. And so the submission simply is that the real issue here is not whether we're talking about principles or criteria, it is what they should be, and that is a matter for the expert evidence. Turning to existing use rights and policy 5, during the hearing, Commissioner Cubitt questioned the legality of policy 5 and mentioned the Southland District Council and Charteris case. Short answer is that Commissioner Cubitt was correct. The regional policy statement contained existing use rights under section 10, save for the natural hazards section. Eco P5 is in conflict with section 10 of the Act, and so accordingly the section 42A author has recommended that it be deleted. Moving on to the memorandum that Sanford Limited has filed. So Ms. Appleyard, as counsel for Sanford, filed a memorandum addressing the terminology in section 6 of the Resource Management Act. She submitted section 6 as subordinate to section 5. Section 6A and B refer to inappropriate subdivision use and development. While section 6C does not contain this qualifier, that does not mean its requirements are absolute. The nature or level of protection required must be determined by a territorial authority or regional council preparing or reviewing its district or regional plan. For example, 6C does not exclude the possibility of offsetting to manage adverse effects on 6C matters. The language used in section 6A, B and C accordingly does not result in a requirement for greater or lesser emphasis to automatically be placed on section 6C. So paragraph 460, I've said with respect, I disagree. It should actually say with respect, I partially disagree. Because I do agree that, for example, offsetting is available for section 6C matters, and that's exactly what's been done in the regional policy statement. I've set out the relevant passage in King Salmon, but the key point that I want to make is that when you're comparing 6C with A and B, for example, in accordance with ordinary principles of interpretation, the omission of the from inappropriate subdivision, use and development must be taken to be intentional. Words that go into statutes are to be given meaning. Equally, the absence of words in this case is to be given meaning. It's quite clear from the scheme of section 6 that significant Indigenous biodiversity has an unqualified recognise and protect requirement, whereas A and B have a qualified requirement. That said, 6C is not an absolute. And it should be noted that the protection in the RPS is not an absolute protection. And it's all the provisions that I ran through earlier. It includes the effects management hierarchy for some activities. Set that in my neat little table when somebody types it and I hand it up after lunch. So those are my submissions on the eco chapter. In attendance, Mr. Lloyd and Ms. Hardiman. I notice it's 10:05, and if there are any questions for the author of the report that's attached to the reply report on coastal ecology, we should probably drag her into the meeting by Zoom. We have that's Ms. Miller.
She is online.
Okay, we can invite her in.
Good morning, Ms. Miller.
Morena.
Look, you may or may not have seen comments that I've made to other report writers that we are looking for clarity on our questions if we have any. So don't be upset if you don't receive any. That simply mean that your statement to us in reply was clear. So, but there are a number of other report writers on this particular subject, and Mr. Anderson has just finished his legal submission, so there will be possibly questions to any one of those persons. And I'll start with Commissioner Cubitt.
No, I don't actually have any questions, but thank you for your input.
Problem.
Okay.
Yeah, just one question on the legal submissions here. Page 73, clause 450, paragraph 453. I just did a quick search and I see that you referred to for natural inland wetlands that appendix 6 and 7 have to be complied with. But that's only for natural inland wetlands, isn't it? It doesn't, that requirement to comply with the principles in 6 and 7, appendices 6 and 7 doesn't apply to areas, freshwater areas outside of natural inland wetlands. Is that correct?
Oh, double check that and come back.
I just did a quick PDF search, but that's the only one that sort of came up, and I thought, it's sort of reasonably limited if it's not going to apply to, you know, rivers and lakes and.
Yeah, it's not cited for that point. That what Mr. If I understand correctly, what's being sought is that essentially we cut and paste that regime and use it for Indigenous biodiversity, and also to support the proposition that we should be having principles relating to offsetting, not criteria that have to be complied with.
Yeah, no, and I take that point, and I also see that it has to be complied with. But I suppose my comment was that it's only for inland wetlands. Does that impact on your position there or not?
It doesn't impact on the point I'm making as to whether that's the limit of its application. I'm just hesitant to say yes, because I know that these X management criteria are incorporated by reference. So I just need to go back and double check before.
Yeah, and that's a good. Yeah, no, and it is interesting that they call them principles, but then says they have to be complied with.
Yes, it's a curious way of saying it.
Mr. Anderson, can you check that for us?
Yes.
Yeah.
So maybe we should go. No, just yeah, I did have a couple of questions on the officers' report. One of the things just in relation to paragraph 48 of the reply report, and I suppose just wondering, I mean, Dr. Lloyd's advice is that a guidance document focused around the Appendix 2 criteria would be useful, and I know we've heard from some of the other ecologists too that would be valuable. I just wondered, do you think that's too specific to include in the method? Is there a way that we can commit to that, or do you think? I mean, I was thinking that there's something quite specific to be including in a method. Would you agree with that, or just wondering whether there's an avenue through this process to provide for that?
Yeah, I would agree with you. I don't think it would be too specific for a method. I'm sure the avenue for implementing it.
I guess, yeah, I suppose it's something that, I mean, we can potentially signal through our decision if we think it's something. Now, I did have one other point. Just find it. Sorry, no notes of which paragraphs I have questions on here. I think that point's been covered. Sorry. No, I think that was all for me. Thanks.
Anderson, just looking at section 6, there's one other aspect to it in terms of looking at whether or not there are qualifiers or not qualifiers for A and B, qualifiers for C, no qualifier. But then there's another nuance or distinction that you haven't touched on that I just would be interested in your views as to whether the use of the word preserve in relation to the coastal area in section 6A is indicative that there's almost a hierarchy, if you like, that's a bit more complex than you put, i.e. preserve in respect of the coastal area, protect in respect of other areas that may, from inappropriate. So you've got qualifier. Then in B, you have the protect and the qualifier. And then in C, you just have, as you've outlined, the protect but with no qualifier. Do you accept that use of the word preserve indicates that the coastal area has a direction that is at a higher level than the other use of the word protect on the other subsections?
It's certainly a different word, and applying the same reasoning that I just indicated, that the words need to be given meaning for a reason. That does seem to indicate I'm just struggling to see preserve as having a meaning which is a higher level of higher level than protect. In terms of the ordinary meaning of those words, I would have thought protecting something that is actually what would actually come at the top of a hierarchy, but that doesn't seem to be the way it's written in section 6A. I'm wondering if it would be useful to check if there's any case law on that point.
Yes, well, I'd be intrigued to know whether there is.
So, can I give myself lunchtime to
Oh, yes,
check
yes,
that and
indeed, if you could.
respond?
Yep, no, that's fine. The other questions, I think you've followed your legal submissions very clearly, thank you. Any other questions? Just if I can turn to some of the other report writers, and possibly just whilst we're on the coastal marine aspect of it, I was left in a state of uncertainty in terms of your report, Ms. Miller, just and in one respect, and that was just dealing with the issue of ecological baselines and your paragraph 18. And I read that and was looking for the conclusion as to whether you thought there was a possibility of having a baseline or not. And you don't actually give us that conclusion. So what is it? What do you say is the position?
Yeah, thank you, and just good point. So at paragraph 21, it's a little bit difficult as I've come in relatively late to the piece and haven't been involved in the caucusing. So I'm reluctant to insert too much certainty into this without having been involved in the prior conversations. I suggested that, hang on 1 second, I'm sure you could hear in the background.
We were having a problem, but it's come clear now.
Hopefully that's a little bit easier to hear. Yep, so I've suggested that, the definition of a marine ecological baseline would be of benefit, certainly to the representativeness criteria. However, sort of within the constraints of my evidence, it wasn't really able to be ascertained as to what that ecological baseline definition would be. I think representativeness is an important criteria to have for the marine ecological space, as I laid out in paragraph 19 and 20. However, I think it's possibly something that would be useful to further define, perhaps in the what was the document you were discussing before, whether it was going to be in methods. Yeah, perhaps within the guidance document. as to what a marine ecological baseline looks like. There are a lot of complexities around ascertaining it. However, it's not impossible, and I think it can be done. It just needs further clarity and work on it to make sure that that's fit for purpose, in my opinion.
Okay, thank you. Ms. Hardeman, just some matters that I can from your reply. One of the, and Dr. Lloyd too, one of the, find it, is Appendix 3.2H, the issue, I think it's 2H. Yes, there's 2H. The Dr. Keating suggested that the outcome of offset being achieved during the duration of the resource consent was unnecessary and unrealistic. He gave the example of the maturing forest. Dr. Lloyd responded that confused offset outcome with ecological. But by just sticking to those words, the very error that you say, Dr. Lloyd, that Dr. Keating has fallen into, it seems to me is highly likely to be an error or an interpretation problem that people will have without doing the very differentiation that you've done in your response. So you've said that it's confusing the offset outcome, ecological outcome, but that isn't differentiated in the wording. And is there any problem with just changing the wording slightly at the start to say that something to convey that the no net loss outcome is achieved during the duration of the consent? Is there a problem from your viewpoint with actually differentiating that difference that you specify?
No, there's no problem from my point of view. I think it's often done that the offsetting outcome is to be achieved within the lifetime of the consent.
Yeah, but that outcome you're identifying really is the no net loss outcome,
yes,
rather than the preferable gain.
Yes, the gain should keep on growing and changing.
Yeah, and when we're talking about that no net loss and preferably gain, I might be misunderstanding what Dr. Keating is saying and suggesting that the no net loss can be deleted. But in essence, he's saying if you have a gain, as I understand it, if you have a gain, you're necessarily having no net loss.
That's correct. You must have exceeded no net loss to achieve a gain.
Yeah. And the wording in relation to Appendix 3.2e referred to that issue of perpetuity, and Dr. Keating considering the statement preferably in perpetuity is unnecessary and unrealistic, essentially, is the implication. The response to you, Ms. Harding, was that you didn't accept that proposal to remove that wording, and because the offsetting outcome will continue past the impact of the activity, and the words support that. In the column for response from Dr. Lloyd, there was a gap. Did you have a view on it, Dr. Lloyd, as to the necessity of that wording, or whether it's realistic, really, in an RMA sense, to be talking about perpetuity?
I guess it's aspirational. yeah, that's how I would see it.
Right.
But practically, it wouldn't be possible to be confident that the outcome would be achieved in perpetuity. You know, we're a shaky isles and there's all kinds of natural disturbance factors that can destroy indigenous biodiversity, for example.
Sorry about this, but it's what happens when you long report. Just want to make sure that just Ms. Hardiman, the Eco P4 at the new 1A recommended in relation to one two issues. Yes, I'll deal with the first one first. In 1A, there's a reference to recommended reference to significant national public benefit. And then in relation to aggregate, there's provision for significant national or regional benefit. Two questions really arise out of that. What's the purpose of inserting the word public is the first question. And secondly, why is there no recommended regional benefits able to be taken into account in that 1A?
So this approach was taken from the National Policy Statement on Highly Productive Land.
Sorry, second B.
The approach taken in 1A and 1B has been adopted from the National Policy Statement on Highly Productive Land, in regard to mineral and aggregate extraction.
Right. Yeah. Thank you. And then the other thing was that I've lost the place as to where you said it, but so I can't take you to it. You might remember, but there was previously the word "new" in relation. I thought in relation to that. Oh, yes, here we are. At your page 81, you have previous version that commenced with the new use of development and in relation to each of 1A and 1B, but it was shown as being deleted. And I'm really just trying to track down where did it come from and when was it recommended to be deleted. And I'm just, in you answering that, can you just look at the heading for Eco P4, which is provision for new activities. So the word "new" was, it would appear to me from your page 81, recommended to be put in, I would assume to reflect the heading, but then is now recommended to be deleted. There wasn't any discussion of that.
Yeah, so in my opening statement, I addressed that was in response to Ms. Hunter's submission.
To
Ms. Hunter,
yes.
Oceana Gold.
Right.
So that was for clarity between Eco 1A and the clause to clause 2. Just so that they're aligned, because the clause 1 and 2 didn't refer to new use. So I can see your point though, that the provision is deals with new activities. Yeah.
All right. Okay, well, we'll have to grapple with that. Thank you. So final question really that I just had in trying to gain clarity on all these reports was, Dr. Lloyd, at your page 9, you had a highlighted phraseology. So this was your discussion of the appropriate baseline amongst marine experts you suggested could be agreed as set out below. You suggested an indigenous marine ecosystem or habitat of indigenous marine fauna, and brackets including both intertidal and subtidal habitats, and including both faunal and floral components, close brackets, that is characteristic or typical of the, and then you had the words appropriate baseline and brackets, square brackets, so typical of the natural marine ecosystem diversity of Otago. It seemed to read well without the highlighted words. What are you meaning by those highlighted words?
Well, the baseline and the representativeness criterion reflects a standard of structure and composition that the current state is compared with, and examples that match that standard would have high representative value. So if the standard isn't there, you've got nothing to compare against.
Okay. Thank you. And
Sorry,
Yep.
I actually did have some questions. I thought we were just questioning Ms. Miller first.
right. Okay.
But you,
I finished.
yeah, well, you actually asked some of them, but Ms. Hardiman, in relation to and it's the existing use rights issue, and I know you recommended that be taken out of particular policy, but there was some benefit, I thought, when we had the discussion with that policy around allowing for some upgrades of existing activities there. And I think that came through in your earlier recommendation. Wasn't there originally, was it?
Yeah, through the section 3.
Yeah. But I guess, given you're promoting that it goes completely, do you see the minor upgrades as probably part and parcel of an existing lawfully established activity? Because I could see the benefit of what you were talking about there in your original report. But there may be something just not to go near because of the section 10 issue, but
I'm not sure, sorry.
no, that's okay. I just wanted to understand what you thought minor upgrades in the context of section 10 might mean. But the only other thing was around the Taaka species in the conversation you had around that. I'm just trying to get my mind around how that may work, because I think we had the discussion around Manuka and Matagari and stuff that is pretty prevalent in Otago. So that process would be effectively a discussion at district plan level where iwi would identify significant taka and how that might be managed. Yeah, so it's not a straight out, well, it's a taka species, but so it's not necessarily an avoid approach, probably more of a management approach that they were sort of promoting through that change.
Like a two-tier management approach.
Yeah, okay. I was also going to ask probably an unfair question about that could otherwise be achieved with the New Zealand reference from the national policy statement, what that actually means from your planning experience, because I'm not quite sure what that means.
Well, for instance, clause 1A in regard to mineral extraction.
Yeah.
There's a gold mine up in Waihi. So that benefit could be achieved in the North Island compared to, say, the Grace district.
Sorry, I didn't hear that.
My understanding of the section that Mr. Cubitt has just read out is that, sorry, I'll just read it out again. That can the benefit can otherwise be achieved in New Zealand. My reading of that is that if there's another gold mine occurring in New Zealand, then that means that the Macraes, that benefit's already occurring somewhere else domestically, i.e. up in Waihi, at the gold mine there. Yeah.
Kind of doesn't though, doesn't it? Because it's adding to the benefit. Yeah. I guess in the original question around what does regional mean in the context of the aggregate, what's the regional benefit, given how pretty important from an economic perspective to be close to the source. You've got any thoughts around what that may mean? Is it a different type of aggregate that can't be found somewhere else, or was it an economic issue?
I took that from the from the national policy statement.
Is there any in the guidance notes to that policy statement that talks about any of that?
I couldn't find anything. No. Yeah.
So we can make it up. But thank you for that. The only other thing I had from Mr. Anderson was actually in relation to highlighting the certain principles that need to be vital and some that just need to be had regard to. Were you suggesting in that context that we need to make that distinction in the criteria here? I wasn't quite sure what you got with that.
No, it's definitely not. The point was simply noting that despite the label principles, that the important parts of that do in fact have to be complied with, and there's no material difference. I'm not suggesting that we need to distinguish our criteria and to comply with this, but only think about complying with that.
The criteria are the same, though. Would be directed by the national legal document to actually take that approach.
Well, I don't think so. The two documents apply to different things.
Yeah.
And eventually submission would defer to the expert evidence as to what the appropriate criteria are in the context of terrestrial biodiversity as distinct from what the MPS was dealing with. I think that's essentially an expert opinion matter as to what limits there need to be on the availability of offsetting for significant Indigenous biodiversity in that terrestrial context as distinct from freshwater.
I can't recall what the exposure draft says about that, whether there's that split.
Sorry, I can't find that. Whisper. If it's something relevant, share it after.
Yeah.
With the other things to report on.
Okay, well, thank you for that.
Sorry, there was one further question that I had at page 40 in your table in relation to including consideration of Mātauranga Māori. We're struggling. That's 3D, is it? Should we be correcting your 3E reference to 3D on the left-hand column?
Sorry, let me just bring it up. Yes, it should be APP 3D.
Right, and then in the second column on the right, your analysis where you say, I consider my recommendation to replace consideration with application in response to Ms. Bartlett. So was 3D, oh, I see, so 3D was, that doesn't appear in the change, but as a change, but I take it that's because 3D was new itself and you now included application rather than consideration on that.
3D was a section 42A recommendation.
Right.
Yeah.
Yeah. Okay. Yeah. Thank you.
There is one further thing for Ms. Hardiman to do, which is there was also a missing section 32AA. But from the reply report to do with APP3. So you have that.
So I'll read it out to you now.
Yes, and will there be a written copy?
Yes, yeah.
Thank you.
In terms of a section 32AA analysis, I consider the recommendations and additional direction provided to APP3 are more effective at achieving the outcomes sought in ECO 01 by ensuring any net decline in condition, quantity and diversity of Indigenous biodiversity is halted. I consider that the amendments are the most appropriate to achieve the purpose of the RMA because it assists in achieving ORC's function of maintaining biological diversity under section 31GA. The requirement for an offset to accord with Mātauranga Māori when Taioka species are affected and to apply Mātauranga Māori where it is available to an applicant is more effective in achieving the outcomes sought in ECO 03 because it enables mana whenua to exercise their role as katiaki of Otago.
Thank you. Thank you. We'll have a break now for come back at 11 o'clock. first rinse. Here we are.
Yes, well, perhaps first just to answer a couple of questions that popped up in the previous topic. So first, Commissioner Hubert asked whether the appendices to do with offsetting in the exposure draft National Policy Statement for Indigenous Biodiversity also had to be complied with per the draft. And the relevant, and this is just to give the references, I think. So appendices 3 and 4 of the NPSIB exposure draft are the offsetting and compensation appendices, and they each say the following sets out a framework of principles for the use of biodiversity offsets or compensation in the other one. These principles represent a standard for biodiversity offsetting and must be complied with for an action to qualify as a biodiversity offset. The keywords being must be complied with. And that applies to all of the principles, not just a subset. But I would reiterate, as we've submitted before, this is exposure draft. It's been sitting with Cabinet for 12 months. Who knows what will happen to it?
13 years.
Good point. The question around the National Policy Statement, freshwater management, advanced management hierarchy. 3.22 was the provision referred to in submission. 3.24 has the equivalent provision in context of rivers. And we're talking about the loss of extent and values in the case of, well, in both instances. And Indigenous biodiversity is one of those values, not all of them. It's important to note also with the MPS FM that in terms of clause 3.12a, a local authority is not prevented from adopting a more stringent approach should it wish to do so. And we should also note that we're talking about significant Indigenous biodiversity more broadly in the present context. The final point is the Chair's point concerning the scheme of Section 6. And in terms of case law, a quick search and discussion with a colleague with a longer memory than mine suggests that king salmon is in fact the best discussion. I refer particularly to paragraph 28 in king salmon, which actually before that I should probably just note that looking at section 6, 6A, which begins with the preservation of the natural character, etc., goes on to say, and the protection of them from inappropriate subdivision, use and development. So it says preserve and protect, and then has the qualifier inappropriate subdivision, use and development. The discussion in King Salmon at paragraph 28 makes nothing of distinction between the words preserve and protect, and it says it's significant that 3 of the 7 matters of national importance identified in section 6 relate to the preservation or protection of certain areas. either absolutely or from inappropriate subdivision, use and development. Like the use of the words protection and avoiding in section 5, the language of section 6A, B and C suggests that within the concept of sustainable management, RMA envisages that there will be areas, the natural characteristics or features of which require protection from the adverse effects of development. So the point that I draw from that is that the court doesn't make anything of the distinction between using preserve or protect. But it does note that the protection is either absolutely or with the qualifying words inappropriate subdivision, use and development.
Thank you, Mr.
I think that concludes the eco chapter and will bring us to coastal environment. So Mr. McLennan is in attendance to answer any questions. I do have a brief legal submission and to answer the which page question. You know, as soon as I find it.
Page 48.
Thank you. Right, so there are 2 points for legal submission. The first is policy 5 in the coast chapter, which is the identification of coastal indigenous biodiversity, and the second relates to 2 methods, M36 and M46, and the concept of scientific uncertainty. CEP5, first point to note that in the reply version, this policy has shifted location. It's now found in the eco chapter. Underneath where eco P7 has been deleted on page 202. And this is the policy which provides that indigenous biodiversity in the coastal environment be protected firstly by identification of indigenous biodiversity and then by the avoidance of adverse effects on the types listed in P5.1 or avoiding significant adverse effects and avoiding remedying or mitigating other adverse effects on the biodiversity listed in P5.2. 2 issues were raised during the hearing. The first was whether identification is required by the NZCPS, and the second was whether the Regional Council is assuming too onerous an obligation to identify indigenous biodiversity in the coastal environment, particularly for the coastal marine area. As the Chair pointed out, policy 11 of the NZCPS, which deals with indigenous biodiversity in the coastal environment, does not expressly require identification of indigenous biodiversity in that environment. In comparison, policies 13 and 15 do. So the Chair's observation is plainly correct. However, there is nothing which prevents a regional policy statement from going beyond the NZCPS, and indeed the function of the regional policy statement is to articulate at a regional level how the NZCPS will be implemented. Policy 11 of the NZCPS requires qualified protection of specified indigenous biodiversity. Effects on that biodiversity cannot be avoided where required, or in other cases avoided, remedied, and mitigated, unless the existence and location of the biodiversity is known. In other words, identification is necessary to give effect to policy 11. Chair also asked whether the Board of Inquiry report on the draft CPS elucidated why there was a difference between policy 11 on the one hand and policies 13 and 15 on the other. It's clear from the report that the board expected that the Department of Conservation would provide the information necessary to implement the policy. It's therefore understandable that identification of Indigenous biodiversity is omitted from policy 11. And because the NZCPS is directions to local authorities, not to the Department of Conservation, which is where it was expected the necessary information would come from. As it happens, that information has not been collated and published by the Department of Conservation in the way in which the board anticipated. That leads to the second point about what information is actually available. The concern was that, at least in the marine environment, little work had been done and the Regional Council was imposing on itself a significant and costly obligation. Substantial progress has in fact been made by the Regional Council through the NIWA report, Identification of Significant Ecological Areas for the Otago Coastal Marine Area, June 22. Although the report does identify gaps in the available information and makes recommendations for cost-effective ground truthing and monitoring programs. The Regional Council doesn't resolve from the task of identifying important and vulnerable biodiversity in the coastal environment. In other words, it doesn't consider the obligation too costly or onerous in light of what's already been done. Second point is to do with the two methods, M36 and M46. These methods direct that regional and district plans require a precautionary approach in assessing the effects of activities on the coastal environment, where, among other things, there is scientific uncertainty. During the hearing, the panel asked whether scientific uncertainty extends to gaps in knowledge. The answer is that deficits in knowledge in this context do create scientific uncertainty. Identifying species and obtaining information about the effects of activities on them are matters of science. When there are information shortfalls, there is scientific uncertainty. And to that I would add that essentially where we have gaps, there is going to need to be a precautionary approach. So those are the legal submissions. I'm happy to answer any questions. Mr. McLennan is in attendance to answer any questions the panel might have for him.
Good morning, Mr. McLennan. You in contact
Good
with
morning,
us?
all. Yes, and thanks for accommodating me today rather than yesterday.
That's all right.
Answer to be a bit more coherent today, hopefully.
Okay, thank you. So we'll start with questions for either council or yourself, Commissioner Cubitt. Thanks.
Morning, Andrew. Hopefully you're feeling a bit better today. I didn't have a lot of questions for you actually at all, really. Your report's pretty clear, but just in relation to CEP 14, are you in paragraph 192, is that, are you recommending that we retain that? Well, I found it.
So my recommendation for this one would basically that you could either have a policy or you could retain the same content within a method. So my final recommendation basically was that I was comfortable that the direction within the suggested CEP 14 could also be a method.
Yeah, okay. I just wasn't quite sure where it ended up. And so I note in relation to the sediment issue, in the context of some other parts of the policy statement, Mr. Oliver for Sea Forest recommended some amendments around the impacts of plantation forestry. I'm not sure if you've seen those, but that's something we can consider, I guess.
No, so I guess the method as drafted, or I guess as you'll see in paragraph 196, I didn't have a firm view as to whether it should be a method or a policy, but this direction is comes directly from the NZCPS. So that's basically why that's where the drafting's come from.
Yeah, okay, great. Okay, thanks for that. Cheers.
Yeah, Morena, just a couple of points from me. Just at your paragraph 7 around CEO2. And I'm presuming this is just something that hasn't carried through into the reply report, but you're recommending the maintained or enhanced be changed to maintained and enhanced. And you referred back to section 60 of the RMA on that. That hasn't carried through into the reply report. I'm presuming that's just a oversight.
Sorry, what paragraph reference was that?
27 in the reply report.
Yes, that's right. Yes, so the reply report, your reference. So the version in the reply report paragraph 27 is correct, and that you're right, that hasn't carried over to the track change version of the plan.
Because I was sort of wondering how, and taking your point about section 60 of the RMA, which does talk about maintain and enhance, how you can actually do both at the same time, I suppose, in a practical sense, which I suppose, you know, the RPS is a little bit more practical than the RMA. We're hoping it will be. Have you got any kind of comment on that? And I know it's something that you just discussed slightly, but I suppose I just wonder if there's going to actually be some tension about what is trying to be achieved if you're trying to do both together.
Yeah, that's a good question. I had thought more of it as though the areas that already have public walking access are maintained and other places could be enhanced. So doing them together that way rather than, so maybe in a different geographic location, this area is maintained, this area over here is enhanced. That was, I guess, the way I had read that addition.
So maintain access where it's there and enhance it where it's not.
That's right.
Yep. Just have another question. At that point, sorry. Sorry, I'm just catching myself up here. No, I can't make sense of my question there. So read it twice, it doesn't make sense, it can't be valid. No, sorry about the delay there, but no, that's all from me. Thanks.
Ken, the main issue I've got really is just, and I need you to really refresh my memory, that where there is an uncertainty, and this area of the coastal marine seems to be the area where that is an issue, and Mr. Anderson's drawn attention to those reports that identify that there has been a level of work, but plainly from the evidence of Ms. Giles and also Ms. Miller, there are still major gaps in knowledge, and that was pretty plain too from the presentation by Sanford in terms of their offshore deep salmon farm proposal, which was had a heavy emphasis on adaptive management. And I know that you've got the experience from the Marlborough Sounds area of that being a very heavily utilised means of overcoming the lack of knowledge in the marine environment. But I can't recall seeing it identified in this coastal area of the RPS, and particularly in those methods, which were Mr. Anderson referred to, CEM 3.6 and 4.6. So 2 questions. First, am I overlooking it somewhere in the coastal marine chapter of the RPS at the moment? And if it's not there, should it be? And should it be, in that sense, in a policy? Should it be that method led?
So in answer to your first question, no, you're not overlooking it. The only reference, and I guess it is as the standards set out, is in P36, M36 and M46. I would maybe note that the adoption of a precautionary approach within those methods could include adaptive management in my understanding. So while it's not said, while the words adaptive management aren't there, the precautionary approach could include an adaptive management approach, I would suggest. But maybe it needs to be more specific. And if so, I think method CEM 3.6 and M4.6 would be the appropriate place for those.
Sorry to interrupt, I think I can assist with that. There's an addition to the integrated management chapter, policy 6,
Right.
to include, in context of precautionary approach, including through use of adaptive management. And that change is intended to signal that adaptive management is a method or a tool that can be used or is contemplated by the regional policy statement.
Right.
But rather than having individual references scattered throughout the statement.
Okay. Yes, I suppose it's just in a, I think, large measure throughout the nation. It's been the coastal marine area where the adaptive management has been relied upon by resource users, and I take your point though, and I am P6 level 2 specifically addresses that. Is it one of those situations where it's important enough to have that cross-reference, do you think, in method 3.6 and 4.6?
I think similar language could be adopted.
Sorry, Mr. Kinroy.
I think similar language could be adopted for that, and for an inclusion within M4.6 and M3.6 to make it abundantly clear that that's what the precautionary approach could include.
Right. Look, thank you. That was the only issue that I wanted to raise. And
can I just ask a question, clarification? The added provision that you agreed to on Te Mauri of Te Moana. Now, in the recommended version, it's CEA01, and then the final recommendation is CEOA1. Am I reading that correctly? So the numbering got changed around as well.
It has, but there's no magic in that.
Right.
It's just the intention is that this is the first objective that is read in the chapter, which is why it was put in as 1A rather than objective 6. But you're right. I've transposed the A between the
Started off A01 and then finally ended up as O.
Yeah.
Oh, 1A, is it 1A?
Yeah.
All right,
It will just, I guess, once you in the decision, I imagine that will become one, objective one, and then
Okay.
everything will go follow on from that. But to avoid having two objective ones or anything like that, I've tried to make it easier for the numbering, but in the decision, I imagine that will become one.
okay, thanks. Thank you, Ms. James. That deals with the coastal ring.
Yes, so
I do have one, sorry, I do have one
Yep.
small correction, which I've realized, but there's a discrepancy between the master version of the RPS and my recommendation. So this is in relation to CEP 11, the aquaculture policy. Maybe if I start with unfortunately, both of them are incorrect. So starting maybe with the RPS version on page 151. The policy in this version reads has the within appropriate locations and limits struck through, and then it should say where this is in accordance with. So the where this is missing.
Thank you.
And then in my final recommendation on page 48, para 175, it has the correct addition, but the within appropriate locations and limits is not struck through. So that needs to be struck through.
Right. Thank you. Yeah, thank you.
So I think that brings us to hazards and risks, which is at page 81 of the legal submissions. There are 3 points there. One is what power there is under the Act to require existing land use in hazardous areas to end, i.e. managed retreat. Secondly, National Adaptation Plan in section 61(2)(e) of the Act, and thirdly, the avoidance of significant risks. So managed retreat, this is confirming or providing references subsequent to the oral submission I made at the hearing. So the relevant moving parts are section 10(4) of the Act provides that section 10 does not apply to any use of land controlled under section 31C of the Act. Section 31C of the Act gives regional councils the function of controlling the use of land for purposes including the avoidance or mitigation of natural hazards. Accordingly, regional plans may include provisions controlling, including prohibiting, land uses in areas subject to natural hazards. Section 20A provides for limited continued use rights pending regional plan rules becoming operative and determination, including appeals of any resource consent application under those rules. But it's clear that existing uses can be extinguished with those uses becoming unlawful. District plan provisions can't do this. Under section 85 of the Act, if a provision renders land incapable of reasonable use, then any person with an interest in that land may challenge the rule, either by submission on the plan change or herself seeking a plan change. If that challenge is unsuccessful, then if the Environment Court is satisfied on appeal that the provision renders the land incapable of reasonable use, and places an unfair burden on the interest holder. Then it can direct the local authority at the local authority's election to do one of the following: either modify, delete, or replace the provision, or if the interest holder, i.e. the owner, agrees to acquire her interest under the Public Works Act 1981, but only if the owner acquired the land before the provision was notified. And just to expand on that, I'm sure the panel's aware, when land's acquired under the Public Works Act 1981, you have to pay for it. So 490, I would expect that for any significant managed retreat proposal, there would be consideration of factors beyond the provisions of the Act and consultation with the affected community, and that there may be location-specific plan and or policy statement changes. There's a recent example of the exercise of these powers, which was considered by the Environment Court in Awatarariki Residents, that should be Residents Association Incorporated, in Bay of Plenty Regional Council and Whakatane District Council. If memory serves, I think I provided a copy of that decision during the hearing. To that, I would just add that in that case, it's probably an example of how the exercise is broader than just the resource management components. In that instance, there was a combination of central and local government funding, and there was a voluntary buyback scheme where offers were made to purchase residents' land at market value established by valuation process, rather than forcing residents to go through the Section 85 process, which may or may not have been successful for them. And so I think it's another key feature of that is that there had already been a major event which had caused significant damage and made some land uninhabitable. So for any kind of a managed retreat program to be considered, I would expect that there would be a very significant, I guess, political and community exercise and decision-making process. That would only after that has happened flow through into the resource management regime.
Yeah, I was on the hearing panel that did that.
I hope I got it right. So the next point is National Adaptation Plan in Section 61(2)(e) of the Act. So my submissions, 26 April, I set out the relevant part of the National Adaptation Plan. Passage cited stated it was non-statutory guidance that from 30 November 22, councils would be required to have regard to it. Panel queried the source of that date. The date was simply the date that Section 61(2)(e) was inserted into the Resource Management Act. There was another insertion in the form of amendment to Schedule 12, adding further transitional provisions, one of which, Clause 6 of Schedule 12, provides that if a regional policy statement was notified before Section 61(2)(d) and E came into effect, i.e. before 30 November 22, which is the case here, then the regional policy statement must be determined as if those amendments have not been enacted. So for this regional policy statement, you ignore Section 61(2)(d) and E of the Act. However, I would note that both the National Adaptation Plan and Emissions Reduction Plan are arguably, at least in my submission, they are management plans and strategies prepared under other acts to which regard shall be had under Section 61(2)(a) Roman 1. So that's a long-winded way of saying they can be considered, but the right reference to use is 61(2)(a)(1), not the other two. And I've just recorded also for completeness, because it was mentioned quite often early in the hearing that the 2050 target is found at Section 5Q of the Climate Change Response Act 2002, and that the climate change is a particular regard matter under Section 7(5) of the Act. So the next point is the avoidance of significant risks, and this is an example of avoidance of, it's not actually avoidance of an effect, but it's the distinction with avoiding an activity versus here avoiding a risk. So the notified version of policy 3 in the hazards chapter stated that when natural hazard risks are significant, the activity is avoided. Mr. McLennan, in his reply report, has recommended that that be amended so that it now provides significant natural hazard risks are avoided. That's to give effect to Section 6H of the Act. Section 6H provides for the management of significant risks from natural hazards. The key point is that the thing that we're managing is risk, and that so the change is appropriate in terms of Section 6H. My submission is that this is an important change because it's making clear that what we're concerned with is risk management, and to make it, to change policy 3 so that it's not about avoiding activities, it's about making sure that the significant risks that sometimes arise in the context of activities are avoided. There were two examples given at the hearing. One was the Milford Highway and the other was the Clyde Dam. And in the context of policy 3, some concern was expressed as to whether things like that could actually happen any longer. And I think under the revised wording, it's more clear that major projects are not foreclosed, provided that significant risks are avoided. I would comment that the Clyde Dam example, especially if you happen to be somebody who lives below the dam in Clyde, highlights that the importance of avoiding significant risks, particularly where the severity of impact is high. So I think the example given is a good illustration of why a policy of that nature is necessary. The other change, which has a legal component, is Mr. McLennan's change to P2, which to refer explicitly. So P2 is the identifying risks or risk assessment policy. The change is to refer explicitly to the categorisation that results, i.e. a risk is either significant, tolerable, or acceptable. So the change is to make it clearer that when the next policy, P3, is referring to a significant risk, it's referring to significant in the sense that the word significant is used in the appendice which assesses risk. And when a risk is assessed as significant under this policy statement, that is in fact a very high level of risk. And the word significant is not used in this chapter in the same context or with the same meaning as it has in Section 6 of the Act. And despite that, there's still potential for confusion in that you look at Section 6 and it says significant risk, and then you look at the chapter and it says risk assessed as significant. And the fact that the word significant has two different meanings, but that is the nomenclature used by the experts in the risk assessment business And this is not a chapter, or certainly the risk assessment part of this chapter is not ever going to be undertaken by lay people. The key point is simply that we want to be clear that when significant and other terms tolerable and acceptable are used in the chapter, it's a reference to risk assessed under the appendice. So those are the legal submissions. Happy to answer any questions, as is Mr. McKeown.
Yeah, thank you. I guess just in relation to that last issue, and there was quite a discussion around the infrastructure providers and so forth, and I've seen the change, but I'm just, and you've noted there is still sort of some uncertainty with that, and I'm not entirely sure that they would be able to design to avoid in every instance, and maybe the Kaikoura State Highway rail network is probably an example of that, where you're probably not actually going to be able to design around that, and it's the only location they can really go. So given that sort of uncertainty around that, I guess it's a question for you, really, Andrew. What would be the harm in actually somehow identifying in the policy that there are going to be circumstances where significant infrastructure is just going to have to go in those areas, and it may be a significant risk?
Yeah, I did think about that, and that's, I guess, why paragraph 52, I kind of try to set up. I think that it's, given the way APP6 works and the identification, I don't think that they're going to be tripped up by this. But if there is still some uncertainty in the panel's mind, I prefer the drafting of Miss Hunter from Contact. If you were going to include a carve out, I think that that is the right carve out, because it requires a carve out from just limb 1, clause 1, rather than being from the whole clause. So I thought that her drafting, if there was still uncertainty and you weren't convinced that, as you say, these significant infrastructure projects will be able to get to mitigate that level of risk, that would be, I guess, the best version of drafting in my mind to resolve that uncertainty.
Yeah, I read this when I was half asleep the other night, so I probably forgot about your paragraph 52, but yeah, that is probably addressing the issue that still sort of sits there.
Maybe we're just adding that table 8, the risk table in the appendice 6 is relevant to that point.
Yeah, it is.
And in terms of that table, significant is the red parts, and the red parts are either a major consequence, which is almost certain, or catastrophic consequence, which is almost certain, likely, or possible. So I would just like to reiterate that from a legal perspective, the meaning of significant in this chapter is a very high level of risk.
Yeah, the Kaikoura seems almost certain. It is almost certain that it's going to happen again.
Well, I just added in that context that the issue would be if you're rebuilding that road, you may have almost certainty that there will be hazard events, but we're talking about the risk for that road. So you need to design so that the major consequence and almost certain don't apply in the context of that road. I'm really starting to stray beyond my legal brief now, so I think I'll just stop.
Yeah, I understand what you're saying, but I just
I mean, the home tunnel is another good example. Or the home, Milford Road itself, where the infrastructure itself is, you can't ever avoid the risk, and it's at least Kaikoura, it's when we have the big earthquakes, but as I understand it, the Milford situation, it's every year. So the infrastructure has been constructed. If you were to look at that example, you're constructing an infrastructure in a location where every year you're going to be exposed to avalanche risk, but you actually avoid that risk by closing the road. So strangely enough, it's the activity of humans using the infrastructure that gets stopped. And all is you're having the exchanges, Mr. McLennan having the exchanges with Mr. Cubitt. I'm just wondering whether this allows for that, either the Kaikoura example or the Milford Road example. Would they be prevented by these provisions?
I don't think I can answer in the sense of saying that a specific activity would or wouldn't be able to be consented. But I just come back to the risk table. It's not about how often or certain it is that there will be an avalanche or there will be an earthquake in the context we're talking about. It's how likely or certain it is that you're going to end up with a major or catastrophic consequence. And so how that risk is assessed is a function of how a thing is designed or how an activity is proposed to be undertaken. And the example you just gave, I'm not sure if this was the example, but say it's an avalanche risk and that risk is predictable, simply closing the road at certain times is one way that a risk might be addressed to bring it down from almost certain to unlikely. You only get into the red if you've got catastrophic consequences, which are almost certain, likely, or possible, or major consequences, which are almost certain.
If you look at table 7, and if we talk about roads, lifelines in the Kaikoura thing, your major is out of service for a week to a month. That's going to happen in Kaikoura with an almost certain earthquake again. So you are in that risk, aren't you?
I might need to defer to Andrew now, but my understanding of this appendice is that it is important to distinguish between the risk assessment that happens at the plan making stage and the risk assessment that happens at the consenting stage. One being essentially identifying the hazard risk that exists in a certain area for a certain type of hazard, and the second being that the risk that attaches to the specific activity that's being proposed. I better actually stop talking now because I'm straying into out of my subject area rather than just saying it and then carrying on.
Okay, where are you
I'm going to pick up on something there, Simon. I guess the difference being between the plan making side of things, which is where this table is, so table 7 consequence is proposed to be used. So table 7 is for a zone, an area, a district, and so that's why these things like 25% of the buildings or 50% of the buildings or those sorts of things are used. In the example of, say, a new road or something that is activity specific, this consequence table doesn't work very well, particularly say for a new building or for a new road or for something, because you don't know what the impact area might be. That's why advice note 2 under step 2 says that the matters listed in 1 to 11 provide a useful consideration for territorial authorities and are the primary consideration for resource consent applications. And so essentially what the matters listed in 1 to 11 provide is a more generic or less rigid assessment of what the consequence might be, and doesn't have those quite rigid sort of limits on 10 people dying or particular areas being out of service for a while. So it's there are two different tests in the RPS for that reason, that this table doesn't work well for individual project specific activities.
So in essence, sorry, I'm cutting across you, but in essence, you're saying that table 7 is, as advice note 1 stresses, particularly for plan change, plan review processes, and whilst those factors are relevant for a resource consent application, the reality is you look more particularly at table 8 for resource consent applications. Is that the position?
So you look at the matters listed above the table, so matters 1 to 11, which are the matters that are essentially in the current RPS. That is how you would determine what the level of consequence might be. So you would look at those 12 listed matters as opposed to looking at the specific matters in the table.
Oh, right. Yeah, I stand corrected. Yeah. Mm. Right.
Yep. Okay. Thanks, Andrew. I still think table 7 is probably going to be used in the context of a resource consent. The only other thing I had for you, Andrew, was actually in relation to your recommended definition of coastal hazards, which I think is a good idea, but I was just wondering, was there actually scope for that?
Where in
Sorry, it's paragraph 20. You've linked it to Port Otago's submission, but I'm not sure if they actually asked for a definition or not.
No, I don't think they asked for a definition, but they were seeking greater clarity as to which provisions applied in the coast and which didn't. And so
that's a way of dealing with that. Yeah,
that's
okay.
right. That's a way of resolving their concern that the provisions weren't clear as to which ones applied in the coast and which didn't.
Yeah, okay. And the only other thing was actually for you, Mr. Anderson, in relation to the National Adaptation Plan, which we're very disappointed that you haven't summarised the 300 pages of that. Thank goodness you didn't. You talk about clause 6 of Schedule 12 in relation to the regional policy statement. Just thinking ahead there, and I haven't got that in front of me, but does that apply to district plans? Because we're going to get district plans that follow on from this, and if this doesn't, you've said it can deal with it via that other management plan process, but does that apply to district plans? Will they have to give effect to that? Because if they do, you probably do want to be referring to it in the RPS.
Good point. Check. I see that it does.
Yeah, I just
To be certain.
the cheese on its own.
Oh, yeah, race. Schedule 12.
So it kind of leaned quite a bit of weight to your argument, and that should be considered under that other section if district plans are going to have to give effect to it down the track.
I'm struggling to find that. It might be.
Is your reference to clause 6 correct?
Well, I'm starting to wonder.
So,
Let me double check and answer after.
Yeah.
To later. That's an important point.
Okay, thank you.
yeah, I see one question, and I probably should know the answer to this already, but have there been any managed retreats in the Otago region in recent times or ever?
Not really, so,
Or family?
I think Queenstown is going through a process of that at the moment. Is that right? On Reavers Lane. I think, there's some rockfall risk. I'm not sure if it's managed retreat or.
Is that in, comes off Gorge Road?
That's right. Yeah.
Yeah, you might be right. They may be looking at something there.
Yeah, there's some coastal retreat quite well advanced in Haranui district as well, but they're not a long-term plan.
I mean, because I go back to the Awatarariki example that you've mentioned, as I said, I was on a panel there, and there was a raft of really interesting issues that came up in it. One of them being the fact that the people were actually given the choice to actually accept the retreat and in fact the money that the Whakatane District Council was offering. And the reason why it then ended up in Environment Court is that one particular family decided no, they didn't want all that. In fact, the old girl, was it the old man, the mother and father, anyway, they'd been there forever. And they kept saying, we're not going to move it. Don't care what happens next. But it did raise some interesting sociological issues, you know, that I often aren't, and you don't know they're coming, you don't anticipate until it actually happens. And I often wonder with things like even a policy like hazard and risk policy, just the full extent to which you can actually anticipate things that might happen. I mean, I guess it's already been said here already that the Otago region hasn't and probably won't, is less likely to suffer from the slash challenges in the East Coast and the Bay Plenty area, for example, that sort of stuff. But I suppose the point I wanted to highlight, I suppose, was the sort of personal health and safety concerns that health and risk issues raise. You know? And then at the end of the day, in the Awatarariki example, as people said, well, we have a choice we can make as well. It's a personal choice of whether we choose to play the game that way or play it a different way. It's kind of our choice, which does, you know, I mean, it's not always as straightforward as that, but in that particular case it did, as it went to the Environment Court. Yeah. Okay, so I just wondered whether there might not have been some examples already here that we could point to as ways of, I guess, further elaborating a bit on this sort of stuff we're talking about here.
There are a couple of examples that I can recall off the top of my head, neither of which involve regulatory responses in the sense of making activities prohibited under, say, Section 28 of the Resource Management Act. One was, well, they both involved consequences of flooding. One was a little town called Heriot in West Otago, which was obliterated by a flood and property became uninsurable. So that was acquired. Some resistance by some of the landowners, by the central government. The other more striking example is around Alexandra, where as a consequence of the major floods in the 1990s, deals agreed by Contact Energy and the Crown, and land, both residential and commercial and public land, was purchased and retired from use, and flood scheme installed on part of that land, and the balance is really public open space now. So that's, if you know Alexandra, that's the open area along the true left bank of the Clutha and then up the true right bank of the lower Manahira.
I mean, I think it just strikes me also that one of the real challenges for regional councils or local authorities is just when a hazard occurs, or a flood or whatever, it's just getting everybody together, getting all the various bits together to, coordinating the sort of response to it. You've got 5 minutes to do it almost, kind of stuff, and whether or not an RPS or any other sort of mechanism of that kind can sufficiently prepare a local authority and others. I know they eventually do come together because power station, the power companies will inevitably get drawn into it very quickly. Often they're one of the first, but it's just sort of coordinating that whole effort that's required to deal with it that can be as challenging, if not more challenging, than some of the other things that we talk about.
I think it's a good point, and that two things from me. One is that the regional policy statement, whether we're talking about managed retreat or dealing with hazards more generally, is just one part of the equation, setting a policy direction. But in context of hazards, the submission is that we need a strong policy direction, because that strong policy direction is crucial to steps that may or may not be taken in subordinate instruments.
Thank you.
I just really, Mr. Anderson, want to discuss with you your paragraph 513. Question really, I suppose, is what makes you say that section 6H is talking about significant hazard risk at a lower level than is contemplated by the PORPS?
Oh, well, I actually was trying anyway to be quite careful not to say that, because I'm not sure about that at all.
The question indicates that maybe you were deeply original.
What I can say with confidence is that when significant is used in this chapter, and after applying the method in the appendix, that it is a very high level of risk, whether section 6 uses significant at the same, well, I'm certain it's not the same level, because we've got our own appendix, which is quite specific. Whether it's higher or lower, I don't know. I think, I guess I should elaborate on that, I would read section 6 as using significant in its plain and ordinary meaning, and that the task that we have in this policy statement is to take that a step further and do things like this policy statement does, provide some policy direction on how you assess risk, and once you've assessed risk, how you deal with it.
I mean, if there is a possible difference between the two, should that be clarified by a definition of significant risk as being as defined as assessed, if that was the best word, in accordance with Appendix 6?
Well, that was considered, but the solution arrived at was to include the express reference in policy 2. So, let's find it. So that way, when you read through the policies, you see policy 2, assess natural hazard risk as significant, tolerable or acceptable.
I see.
And then policy 3, if significant, then if tolerable, if acceptable.
Right. And then that takes you to step 3. In Appendix 6, which starts off with that wording. Identify the risk from each of the scenarios as acceptable, tolerable, or significant. And then have the footnote to table 3, fine colouring with red is significant. Yeah, okay. Follow the sequence. Thank you. I was overlooking that change to P2. Yeah. That's good. All right. Thank you. That was the only question that I had. So
Could just ask one more around, and it's probably for you, Andrew, in terms of step 2, and you spoke about the advice notes here. Would it assist if advice note 2 was extended out to designations and those sort of requirements, which I would think would sit probably more comfortably with resource consents as opposed to plan changes, even though that's kind of spot zones, just to deal with the infrastructure issue, because generally they're quite often they're dealt with via the designation process.
Yes, I guess in addition to advice note 2 might be helpful in that sense, just to highlight that that's the way the designation might be treated.
Yeah.
Should be treated.
Okay, thank you.
I've just noticed that one of the changes that we did include in my reply version is not in this. So Appendix APP 6 Table 3, the risk table, as part of the assessment to this, the ORC's hazards team asked that the major and catastrophic columns in risk table 8 were hatched to identify when a qualitative assessment was required. I was looking at the current version of the RPS, which doesn't, the reply version doesn't have that hatching. So I'm not sure what the best way to do that would be. Maybe Mr. Anderson would send a memo to the panel or something just to show what the table, the reply table should look like. Basically, it should have a hatching over part of that table to demonstrate that that's where the qualitative assessment was required, quantitative assessment was required.
I should raise that in your report, the reply report, that's listed as table 3 at page 44, and it didn't show.
No, so that's an error in both, but it was certainly something that I had supported, and the ORC's hazards team were really interested to see.
Yeah, I remember you supporting that. So it certainly it should be dealt with formally. So if we could memorandum from Mr. Anderson attaching that amended table.
Yes, that's no problem.
Thank you. Thank you, Mr. Anderson. So where are we now?
Natural features and landscapes. Page 86.
All of the tiger, those are.
You and me, I think, yeah.
while everybody's finding their way, a very light-hearted thing that I meant to mention with your hazards submissions was that Ms. Septon prepared in paragraph 48, you referred to paragraph 489.2 to the interest holder agrees acquires further interest under the Public Works Act. I thought that was a nice touch. Anyway, moving on.
I'll let her have the credit wrongly.
That would be same steps.
This is me virtue signaling. So, page 86, natural features and landscapes. Two legal submission points. One is section 7 of the Act and highly valued natural features and landscapes. And the second is the avoidance approach to telecommunications infrastructure. Section 7 of the Act, during the hearing, there was discussion regarding section 7 and highly valued natural features and landscapes, in particular whether there should be requirements to identify highly valued natural landscapes and features under NFL Policy 1 and to avoid significant effects on the values under Policy 3.1, and whether highly valued natural landscapes and features should be dealt with in the regional policy statement at all. The relevant parts of section 7 are C and F, respectively. They are the maintenance and enhancement of amenity values and maintenance and enhancement of the quality of the environment. Decision makers, including this panel, must have regard to these matters in achieving the purpose of the Act. In considering section 7, policies in the RPS, fundamental question is whether those policies achieve the purpose of the Act. Highly valued natural landscapes and features have a definition in the proposed regional policy statement, and that definition is areas which contain attributes and values of significance under sections 7C and 7F of the RMA. In the regional policy statement, highly valued natural features and landscapes are always section 7 matters. Natural features and landscapes which do not contain significant section 7C and F attributes and values fall outside the definition. Put differently, highly valued natural features and landscapes in this regional policy statement are by definition section 7 matters, which must be dealt with in the regional policy statement. And just to express that slightly differently, here the definition is reasonably narrow. It's only referring to attributes and values of significance under section 7C and F. It's directly targeted at those two statutory provisions, and it has a significance threshold. Paragraph 531, it follows the provision for identification of highly valued natural features and landscapes is necessary. Policy 3 requiring the avoidance of significant adverse effects on the values of highly valued natural features and landscapes is clearly directed towards maintaining those features and landscapes. It is not, however, a pure avoid policy. It's significant adverse effects on the values of the feature or landscape which are to be avoided, with other adverse effects to be avoided, remedied, or mitigated. My submission, this is consistent with sections 5 and 7 of the Act, and that while the policy seeks to maintain highly valued natural features and landscapes, which itself is a community wellbeing, there is no requirement to avoid activities within these areas, enabling other wellbeing activities to occur. But this must occur in a way that does not significantly adversely affect the relevant values. The reply version of the regional policy statement includes an amendment which will more clearly enable the use and development of highly valued natural features and landscapes for community well-being, and that is in the infrastructure chapter P13(1)H. And so that's the list of areas to be avoided by infrastructure as a first priority. And it now refers to to highly valued natural features and landscapes rather than areas of high recreational and high amenity value. The consequence of being in that list is that for regionally significant or nationally significant infrastructure under 2A, the requirement is Roman 4, which is simply minimise the adverse effects on the values that contribute to the area's importance. And 2B, 2B takes you to avoid adverse effects on values that contribute to the area's outstanding nature or significance. So essentially what I'm submitting is that provides a clearer pathway for infrastructure. So my overall submission is that P1 and P3, as notified and in the form now recommended, are well within the bounds of how a regional policymaker may give effect to sections 5 and 7C and D of the Act. Next topic is the avoidance approach in telecommunications infrastructure. Council for Spark, Vodafone, and Chorus expressed concern that the strong avoidance approach in the regional policy statement fetters the ability to locate infrastructure in the areas identified as highly valued when there's a functional and or operational need for that infrastructure to be located there. The telecommunications companies, i.e. Spark, Chorus, etc., supported the amended version of NFLP2 and Mr. McLennan's supplementary evidence on the basis that the amendment sought to regionally significant infrastructure is also made. That's the amendment sought in the list of regionally significant infrastructure so that telecommunication and radio networks are referred to instead of facilities. That was sought so that it would encompass the, I'm not sure if it's the entirety, but a sufficient part of their activities, whereas the facilities may not. Mr. Langman has recommended that change be made, and it's shown in the reply version of the regional policy statement. What I'm drawing to the panel's attention is that Mr. McLennan has now recommended a further amended version of Policy 2 so that telecommunications companies' support related to the prior version of Policy 2. But I'm submitting also that because the change to the definition of regionally significant infrastructure has been recommended to be made, if that's adopted, that doesn't matter. It still solves the problem the telecommunications companies were raising, i.e. having a pathway for telecommunications infrastructure, which is now found in the infrastructure chapter. So those are the legal submissions. Happy to answer any questions, as is Mr. McLennan.
Thank you.
Yeah, thank you. Mr. Anderson, this may be a long-winded question, various things, but it's really around the authority that for your comment in submission in paragraph 530 that these things must be dealt with in RPS. Mr. McLean suggests that it appears from his assessment that these things, what have come out of section 7 over the years has been this common practice that we identify landscapes to give effect to sections 7C and 7F. Not everyone does that, but it seems to be the justification for this approach. And I think we had a discussion at the substantive hearing around that those provisions are not always dealt with like that. They're dealt with via general objectives and policies within zones to deal with rural character, open rural character, those sorts of things, which also give effect to section 7 matters. And yeah, when you go back into the definition of amenity values, leaving aside outstanding natural areas, which that's pretty obvious. Amenity values to me, they're quite subjective and they're about people's perception. So to me, it goes back to a local matter almost. It's what the local people perceive in their environment that's important from an amenity point of view. And it can flow into it being a highly valued landscape. But requiring that to be done, I just don't see whether the authority for that, making that mandatory, is in the Act. And then you throw into that the criteria. I don't think there's any landscape architects here, but I'll look at the criteria that Andrew's included, and I know where that comes from, the latest landscape architect guidelines. APP9 is pretty much a list of everything and more that you'd see in a landscape without any sort of threshold of, well, how do we look at those things and get to whether it's highly valued or whether it's outstanding. There's a list that we talked about them last time: settlement, and occupation, roads and circulations, cadastral pattern of land use. There's also wayfinding and mental maps included in that criteria without any sort of threshold. Well, why? How do they make something outstanding? Because all landscapes have those things. And then if you're going to throw that into a lower level, you could end up, Otago's going to have a lot of outstanding natural landscapes. You throw this additional layer over them. I'm just trying to understand the legal context of that when you say it must be dealt with in an RPS.
Okay.
Yeah, sorry, that was a real long-winded statement.
No, it's a fair question, and it may be overstating it to say must be dealt with in the RPS. If I'm using the word must, it would be more accurate to say that the panel must have particular regard to. And the real point that I was trying to stress is that the highly valued natural features and landscapes in this RPS as drafted are confined by definition to those that have significant section 7, C and F features or attributes and values is the phrase used. I can't speak to the criteria in the appendix. That's well outside my expertise. That's for the landscape experts. In terms of and I really should be more careful in saying what must be done. The musters have regard to. It's difficult to see how that could happen without some sort of policy direction in the regional policy statement. But if we're wanting the technical legal position, in terms of what the panel must do to satisfy its obligation once it has had proper regard to those factors. Where that leads the panel is a different question. And probably heading up towards Mr. McLennan's bailiwick.
Yeah, section 6 and 7 don't talk about significance or anything or highly valued. I'm old, so I've been around as long as this act. And initially they were a general thing, that there was no original idea that they would lead into another landscape layer. It was about just generally protecting community values in rural areas or wherever it may be, and quality environment. It was a general sort of have regard to this, make sure you don't mess up your backyards scenario. It's only been probably in the last 10 years or so that the landscape thing has sort of come into it. So it's an evolutionary thing where people have sort of taken it to that extreme. I don't read it in there as the way you read it in there.
Well, essentially what it's saying as it stands, if we just take out the words highly valued features and landscapes, because the definition simply is significant section 7C and F matters. So essentially what these provisions are saying, rightly or wrongly, that's up to the panel, is identify, that's the wrong provision, but identify those things.
I understand that that's what it's saying and that's the direction, but is that an actual regional issue? We've got outstanding. Why is that a regional issue? Because when you look at amenity values, that's the locals to determine through their district plans. And I'm not sure why a regional policy statement would direct on that.
Well, I take your point, but
I didn't stop district councils from doing it. But
yeah, well, my submission only goes as far as saying that this panel is required to have particular regard to those matters, and it is within the scope of what a regional policy statement may do to give the district level some direction, which essentially says, when it comes to the 7C and F things, we want you to identify them and we want you to avoid significant effects on their values. And bearing in mind that they have to have significant values to start with to get into the list. But whether that is what should happen in Otago or not, is a planning and policy matter. My submission is that it can be done. Whether it will be done,
I'm not really arguing with whether it can be done, I guess. And it's the same issue with the regional superbugs. Is that a regional issue? Yeah.
Well, I would. I would add that section 59 is a bit broader in describing the purpose of the regional policy statement than just regional issues. It requires the identification of significant resource management issues in the region, but goes on to require integrated management of natural and physical resources across the whole region. It's the role of the RPS is not confined to dealing with significant resource management issues for the region. I'm still not directly answering your question, which is the fundamental question of, well, should this be being done? And I just have to hand that back to the panel. It's a planning and policy matter, not a legal matter.
Yeah, okay, thanks for that, because the way your submissions were, you were indicating that it was legally required of us to do that, but you're not quite suggesting that.
I'm certainly not saying it's legally required to have this specific policy response. And as acknowledged earlier, I think of reading it again now, I think 530 overstates the position that the must do is simply having regard to those factors.
Yes, having regard isn't a mandatory requirement, or you have to have regard, but you don't actually have to provide for that outcome if you've considered it.
No, once regard has been had, what you'd actually do is up to the panel.
Okay, thank you.
Yeah, I just had one question. And it's just about the interface between the coastal environment and the NFL features and landscapes, and it comes back down to the highly valued natural features and landscapes again. And I see that there's been clarification here in the advice note, but I still look at the definition of highly valued natural features and landscapes, and it does say that it includes seascapes. And I suppose my question is just, is that actually necessary? Highly valued natural features and landscapes, you know, in EIT P13, but that specifically excludes the coastal environment. Are we just potentially adding to confusion by including seascapes in the definition? Or is it necessary if you're standing on some mountain miles away from the sea and enjoying the seascape from something that's where you're actually outside the coastal environment?
No, I think that is just a hangover from an earlier discussion about seascapes being part of a landscape. But you're right, highly valued landscape, natural features and landscapes is only used in the context of the natural features and landscapes chapter, and that chapter explicitly does not apply in the coastal environment. So that addition should be struck through. You're right, it adds to confusion and it's not necessary.
So that's in the definition you're saying.
That's right, in the definition.
Including seascapes should be struck through.
That's right.
What about the heading to, sorry, across, what about the heading to NFL P6? I mean, does P6 just go?
Bear with me. Crystal. Yeah, so this is, I guess, this is just the reverse cross-reference to the coastal chapter, so that it's arguably not necessary. Now the advice note is there, but I guess the intention of that was just to direct people to where the coastal natural features and landscapes are to be managed. Potentially not necessary now that the advice note is there, and the advice note has been amended. So
thank you.
Yeah, no, thank you. That was the only question I had. Thanks.
So, Mr. Anderson, the main concern I had was paragraph 530, and I've just carefully noted your correction, being that I dealt with it by deleting the words "must be dealt with" and wrote above that, which the panel shall have particular regard to in the POR. Yes. Is that your position?
Yes, it is. The panel must have particular regard to.
And the only other question I had, just to get clarity, was at your paragraph 537. So that's related to 313 and the INF chapter. And so, oh, I see. No, I was missing the practical, but that's right at the start. It's not demonstrably practical to avoid locating. Okay. You say that. Well, sorry, can you walk through 537 for me? If the infrastructure is regionally or nationally significant, it is to avoid locating on highly valued natural. Where do we find that? Where do we find the practical reference in that regard?
The practicable comes in sub policy 2. So 1H in INFP 13 is to avoid, as the first priority, locating in those areas. Then paragraph 2 is if it is not demonstrably practicable to avoid locating in the areas listed because of the functional needs or operational needs of the infrastructure, manage adverse effects as follows. And then if you are nationally or regionally significant, that takes you to 2A Roman 4, which is to minimise the adverse effects on values.
Yep. Okay. No. The complication I just get then is not related to your submission, but it relates to B. So for all other infrastructure, i.e. not nationally or regionally significant, how does that interrelate with the highly valued situation? Because B talks about avoid adverse effects on the value that contribute to the area's outstanding natural significance.
The outstanding part wouldn't apply. So it's a simple. So for infrastructure that is neither regionally nor nationally significant, the default position in B is avoid adverse effects on the values that contribute to the highly valued features and areas being significant.
But that's not what B says, though. B just refers to the area's outstanding natural significance as the default.
Well, I didn't read out the outstanding part of it because we're not talking about outstanding, but significance remains relevant. It's outstanding nature or significance.
Right. And I suppose, Mr. McLennan, this is probably an unfair question, but it's the same sort of question that Mr. Cubitt was raising, and just in the perceptual. What on earth are wayfinding and mental maps?
Not something I'm familiar with. I imagine to landscape architects it means more than it does to me. And I guess just to kind of touch on Commissioner Cubitt and your questions, a lot of what's in here, like I guess some of the hazard stuff, which I don't fully understand how the risks and the quantums of things are done. This is a plan that sets up particular things, and landscape architects in the landscape chapter or hazard analysts in the hazards chapter use that information to make a judgment on where these particular things apply. So while I personally can't provide you any insights into what those mean, I'm assured that because we're using best practice, they do have meaning for people who understand what those things are.
Yep, no, that's right. I've got no other questions, so thank you, Mr. McLean. Mr. Anderson, will we?
That brings us to the end, unless there's an entire chapter that I've managed to overlook.
Well, can I just conclude by saying how grateful we are to all council, and I'm sure there were contributions by myself and Mr. Logan to your submissions, but the way you presented them has been extremely helpful to us, and there's been a lot of thought going into identifying and recording over a long period of time now the various questions and issues that we've asked you to address and reply, and we acknowledge the skill that you brought to bear on that, and the care that you brought to bear, and the very practical way in which you've addressed this, and the succinctness with which you present submissions, Mr. Anderson, is amazing and very helpful to us. So thank you for that. And I would just hope that other people could copy the brevity of the sentences that you use, which is a real skill, and it's to be acknowledged. But I also just want to, as chair, acknowledge all of the report writers. A huge task, and we've got a huge task now in deliberating and trying to make sure that we don't miss anything. To have carefully prepared reports that have the level of footnoting references that we've been given is exceedingly important, and we wanted to express our gratitude to all of the report writers for that thought and effort that's gone in. So thank you all very much, and we don't look forward to our next few months. We'll formally adjourn the proceedings as has been recommended to us, and I think that is the appropriate course. I'm not inviting a reconvening of this inquiry, but if in fact, as a result of the Supreme Court decision, it appears to counsel for the IRC that there's some value in that, or to Mr. Anderson or other counsel, then we reserve leave if that needs to be formally done for an application to be made to reconvene for that purpose. Or, and again, I'm not necessarily inviting this, but if when we get to the end of the fresh water hearings, there is some aspect of integration that to you as counsel for ORC suggests that there is a need to open an opportunity for others to have an input on that integration aspect. That again is something that I just raised and leave for your consideration. So, unless there are any other matters, we'll formally adjourn.
Just one very trivial housekeeping matter, the correction or correct transitional provision reference for National Adaptation Plan, I'll file by the administrator, and ditto the typed version of my handwritten table I will also file by the administrator.
And Mr. McLennan's shaded.
Yes, then it's shaded.
In a summary of that,
Eventually.
All right, we'll formally adjourn. Thank you.
Thank you.